I think that your petition, your case, I think has a pretty good shot at the Supreme Court.
I was surprised when I got a call from Samir, our lawyer, and said, "Guess what? The Supreme Court has accepted your case." I thought, wow, because I did not expect it at all. And it wasn't until I parked the car. I got this while I was driving around town. I parked the car and sat there for a minute, and then I read his text, and I thought, holy mackerel, we're going to the Supreme Court.
Well, here we are again. We're back with Talking Racine, and it's new people today. This crowd has never been here before. Welcome to the show, George Myers. You look familiar.
Yeah.
And Jim Spodek.
Yeah.
And who the heck am I? Dr. Ken Yorgan. We're going to talk today about the case that's brought against the Racine Unified School District. Remember the referendum that they had? When the heck did they have it now? Jeez,
April of 2020.
Wow. It's been over a year.
Yep.
And it's still not really resolved. And it went to the courts because Mr. George Myers here and several other people decided, I don't think that result that you came up with is accurate. And I was there and you were there, and we saw things that you spend more time down there, but I saw things that's like I totally understand the lawsuit. I mean, it's like it's like if you came into my store and you bought a candy bar for $1, and you gave me $5, and I gave you $3 back, and you said, wait, this isn't right. And I'd say, no, you bought the candy bar, you gave me some money, I gave you change. Yeah, but I should get $4. Well, I don't know anything about that. All I know is the procedure was right. Yeah. You gave me money, I give you change in a candy bar. That's kind of a way.
That's the procedure. You follow procedure.
Right.
I gave you money, you gave me change.
It doesn't mean the numbers are right.
Exactly. And
that's a good way of describing what our appeal is based on. They followed a procedure, but wait a second, it didn't come out right. You take one vote off of this stack, and then you recount it, and that stack stays the same, but there's one less over in this stack. How the hell did that happen?
Well, and we should explain the whiteboard too. They had a whiteboard down there that was, probably the size of this screen behind us. And they had all of the districts and all the wards and all of the results that were coming in, what the results were originally. And then they would go through a recount and they'd announce what changes had been made, what the new count was. And then a few minutes later, somebody'd go and they'd put the new numbers up on the whiteboard. Except in several instances, the numbers that they put on the whiteboard were not matching with what they announced.
No, that's right. Well, they weren't matched what I was calculating. I don't know what they announced, but in other words, they were putting up numbers that, according to what I saw happen at the table,
didn't match.
Yeah, and they had a picture of me in the Journal Times looking at that table, and I'm thinking, boy, that's very misleading because it looks like, we're being very open. Here's all the numbers, and there's George Myers, looking at the table.
I remember you brought it to their attention. These numbers don't match.
Yeah, but that's what I was doing. I was saying some of these numbers are not right, and I was told. And fortunately, I had a witness. A doc happened to be a witness. He said, "Oh no, we're just putting those up so that the public
got a general idea what's going on.
What's happening. We want to keep be open about what's going on, and we'll when the canvassing comes around, then we'll make any corrections."
And of course, the question is, well, why don't you make it right now? It's a whiteboard. You go like that, and you write down the right number.
Well, I was very, very innocent in those days. I did not realize what can go on elections and recounts and that type of stuff.
Have you ever known him to be innocent?
Not really.
I was with that regard. I was. I really did not know what I was.
Well, we're talking about a $1 billion referendum.
Yeah.
That was it's a big deal.
So anyway, it went to court, and
we should just say this now. It's now been accepted by the Supreme Court. And how did it get
there?
That's the big
That's what this program is about.
It's the Supreme Court has agreed to review the lower court's rulings. And I'd like to kind of start at the circuit court and then go to the appellate court.
Let's tell the story how it got there.
And we can talk about...
It's a worthwhile story.
Yeah, and we can talk about, now, granted, we've talked about this on other shows, that it was the recount was done by the basically the school teachers. It was administered or reviewed by the Board of Canvassers, which was the administration of Unified, and then it was an attorney that oversaw it was hired by Unified.
He was kind of the referee and the rules.
I mean,
and making
this
people
whole
follow
thing
the
was
rules,
kind of a sham, and really, in a way, but. We're not going to go down that road because there's a lot there.
I think most of the people that were there went through the procedure well. They did it,
right,
with all good intentions.
Exactly, knowing, but really, I think the underlying current here. There's so much stuff that went on during that, and I Joe Biden endorsed the school referendum. He was candidate Joe Biden at the time.
He endorsed the Racine referendum.
Yes, he did the school referendum in April of 2020. He endorsed it. Yeah. Huh. Also, now the RSUD is using the attorneys that Biden used in his challenges on this recount or in Wisconsin. So, I mean, there's a lot of correlations there. I don't want to go down there because that's really not the basis of the lawsuit. But I'd like to start at the beginning and then kind of like with law how this proceeded.
Well, and one of the assumptions is that this is the third level of appeal. In other words, it's been reviewed 2 times and been ruled in favor of Unified, and now we're going to the Supreme Court, hoping to overturn the thing. Now that's kind of the perception that's being thrown out there, but that's far from the truth. That's not really what happened.
Right.
Well, let me read a couple of things here from the statement that the attorneys made. Specifically, accepting this case will help develop and harmonize the election law of this state. In other words, there's been some arguments in the past, and it needs to be squared away. The key issue in construction of a state statute, the impact of a decision will be statewide. In other words, this is going to impact the entire state. It's not just Racine Unified School District. It's the entire state is going to be affected by this, and it's being affected in a good way, possibly. He says the decision of the Court of Appeals appears to petitioners to be directly in conflict with state statute. And, I've read through this brief. I know you guys did too. And he's absolutely right. The state statute says that complainants have a right to look at those ballots and review them, even after a recount. You can look at the ballots to confirm that everything was done as it should have been done.
State statute at 7.54. Contested elections, which is exactly what this was. In all contested election cases, the contesting parties have the right to have the ballots open and have all errors and inspections either in counting or refusing to count any ballot corrected by the Board of Canvassers or court deciding the contest. So what was originally done in the circuit court in Racine was it was brought to the circuit court and your suit asked, Your Honor, we feel there's some the count is off, and we would like to examine those ballots that we specifically think are wards in these particular wards. The circuit court came back, said, well, we just believe that the canvassers, the Board of Canvassers, which was really Unified, was correct in their assessment of the election.
Well, the procedure and the process was appropriate.
Right,
procedure which is
and
like
process.
The candy bar.
Exactly. And so now the judge never addressed the 7.45, it's Wisconsin statute. It says you have a right to open and look at those ballots in an open courtroom. That was never addressed. So he just basically passed it on.
When you get down to the circuit court, there was nothing addressed there.
Well, I agree.
No.
I mean, our attorney had put in for a 1-day extension in the time to answer the suit. And the reason for that was because his mother had died. This goes back a year ago.
And that's routine.
His mother died of COVID, and he needed an extra day to handle the funeral and that type of stuff. So he put in for a motion to extend it 1 day, which the judge signed. And being the last thing just before the hearing, it would have been right on the top of all the paperwork that the judge was supposedly reading. Well, when it got to the actual hearing, the judge twice admonished our attorneys for being late, for being a day late on getting the paperwork in. And finally our attorney had to say, Your Honor, we had asked for a 1-day extension that you had approved and signed the approval on. That's why we were a day late. We weren't actually late. We had gotten an extension. And the judge just kind of, oops.
Yeah.
The point being, he hadn't read anything in there, let alone the top page of the thing, that had granted our attorneys an extension, a one-day extension, because of this personal thing with his mother. That's how much attention we got at the circuit court. So you say, well, they were saying, well, this doesn't apply or whatever. The hell, nothing applied. He hadn't even looked at the dang lawsuit. And so that was what went on at the circuit court. So when we say the Supreme Court is reviewing something that went on at the circuit court, really, there was nothing to review that went on at the circuit court, because nothing went on at the circuit court.
That's very routine in a court to offer an extension.
Yeah.
It's not a big deal whatsoever.
But the judge should at least remember that 2 days prior to that, he had offered the signed the extension.
I want to make it clear that this was not an extraordinary thing that the attorney was asking for. I mean, that's just.
But here's one of the reasons. Now we can go into this a brief that goes to the Supreme Court, and one of the I guess questions were at the circuit court. They never addressed the fact that you had asked to view these ballots by law.
No, they didn't address anything.
He didn't address it. But here's what they're saying. What he did address was that the canvassers did it right, and we're just going to move it along.
That's all he said, right?
And that's it.
So
good. What he is saying is, there's the law. It looks good. The procedure worked. Just move along.
Yeah.
So this is your circuit court at Racine.
Right.
They're not, when we've talked about different judges looking deeper into it. This guy, I mean, he hardly glanced at it.
Yeah.
But so, what did you do next? You went.
That, by the way, that was Piontek. So just so we know, we're not accusing all judges or anything. But the point was that's the way it was handled with Piontek. And Piontek, we found out a little bit later, maybe too late, that he had prior connections with Unified, where he had been working with.
He was on a school board.
So he probably shouldn't have even been on the case.
I think he represented him at one point.
Right.
Yeah. All right. So anyway, we go to the appellate court, but there we get fair treatment, right?
That's even worse.
Sorry. Family issues on this one, So I mean that was I mean Lisa Neubauer, who is the Chief Justice there, is connected with her daughter, obviously, Greta Neubauer, and Greta was the former assistant with Corey Mason, who is obviously our mayor, and they're all very much involved with Unified. So when we would go to the appellate court, we got the same type of treatment we got at the circuit court. In other words, nothing to see here. We're making basically the same argument, but they just want to pass it on. Jim, you had a good way of describing it, kicking the can down the road.
Basically, that's exactly what they did. But what they utilized, what they said was, now again, it came to the issue that was brought to the appeals court was, hey, the judge never looked at the statute that said that the petitioners had a right to look at those ballots in open court. So
Not that it wasn't presented.
No, it was presented multiple times at circuit court.
But nobody would look at it.
But they would look at it. So now you take it to appeals court and say, hey, the circuit court never looked at the question that we were bringing up to the court. So he just bypassed it and said, oh, everything looked good. So what the appellate court came back with, when they said they had a summary, anyway, they came back and said...
Summary judgment.
No, they came back with a summary
disposition.
Disposition.
Oh.
Basically a non-issue.
Which is summary means just I don't even have to look at this.
Yeah, we don't have to look at it at all. Yeah. What they're saying is that there was judicial discretion, meaning the judge. It was okay for the judge to say, "Oh, you didn't see anything, and we're just going to let it ride along." So they just basically got on a bandwagon with the circuit court and said, "Everything looks good here."
Well, that's a very important point. That's a very important point, and that is the crux of this whole case. What the summary disposition said was, although the statute authorizes the opening of ballots in court, it does not require that a court do so. Well, it's spoken of as a right. The citizens or the plaintiffs have a right to look at those ballots. So now the appellate court is saying, well, you may have that right, but it's at the discretion of the court.
Right.
Then it's not a right.
Exactly. So how far is that going to go? I mean,
Yeah.
and I think I've read somewhere on a review on this. One of the former judges called it incredible that they would come up with a decision like that. Called it.
It's a right, but it's subject to the decision of a judge or whether you can do it or not. And that is now that
That's not in
now
the
we're getting
statute.
down to the crux of it. That is what the Supreme Court is finally looking at.
Yeah.
This
Yeah.
could have been looked at earlier, and there is no reversal of anything that went down in the lower courts because the lower courts didn't do anything. There was nothing to reverse, and the Supreme Court is finally looking at this statute that says we have a right to look at the ballots, but is that an absolute right, or is it subject to the court? Now, Jim, you brought up something interesting, because now we're going to get down to what they might be looking at. This is an old law. This law has been around since 1905. All right? It's 116 years ago that this law was put into the books. And we've basically been living with it for a long time. And one way of looking at it said, well, it's been there a long time. It's obviously, yeah, it should be, we should be able to look at the ballots. But another way of looking at it is that times change. Things change. Maybe that law really isn't applicable anymore.
But usually those things change when there's a precedent established. Like if a case had been heard and they had decided openly and said, no, that's not your right. That would be a precedent.
Well, now
but that's never happened.
But it may be happening now in 2021.
Yeah. Well, the Wisconsin Act 484, contested elections. In all contested election cases, the contesting parties have the right to have the ballots opened and to have all errors of the inspectors, either in counting or refusing to count any ballot, corrected by the Board of Canvassers or court deciding the contest. Well, now it's a court deciding the contest. Because there was a recount, and what you're saying is you got the math wrong, you added up wrong.
Right.
What's incredible is that this 5-vote margin, even though there was a change by 66 votes out of 33,000 were thrown out for various reasons. They were flawed ballots, whatever. And still, that exact 5-vote margin was maintained.
But here's the thing that I think is, that we should really look at is how this was framed to go to the Supreme Court, actually to the courts, but particularly to the Supreme Court. The attorneys framed it in a way that if you would have gone in the beginning and said, hey, we had to stay 6 feet away from the tables, we felt that the canvassers should not have been Unified School District employees who wanted this referendum to pass. I mean, there was numerous things that were, probably
By the way,
questionable.
that very point became real apparent to me about the 4th or 5th day. That this recount went on for, six days.
Yeah, it was a week.
And it started on a Saturday, and about Wednesday the next week, Tuesday, I began to realize I was an outsider here.
Right.
I'm a party to the contest. I mean, I'm on the paperwork, but everybody else is over there doing things, but I have to stand outside and watch them do it. So it was me versus the rest of the field, and that became very apparent to me. That's when I realized there was something way out of balance here.
But here's the thing: the attorneys didn't take that. They didn't say, "Hey, George felt that he was in an adversarial process." What they did is they took the law and said, "Listen, George has a right to see those ballots."
Right.
And
I'm only bringing that up as a
Right.
matter of perspective. No, I
But
never appealed that.
Right.
I never said anything about that other than I began to realize this is not the way that recounts should go on, where one side gets to handle the whole thing. When there's a recount between contestants, suppose a Democrat versus a Republican. Let's say the Democrat challenges it, the Republican win. For the one candidate to get his people in there and do all the managing of the counting, we would see the inequity. There's not right.
This is a
the other way
referendum,
around.
and referendums are treated differently.
Well, the way the law reads is whoever holds the election does the recount, and between these two candidates, it would have been the city court clerk or the county that was doing the electing, and so they would hold the recount, would be more or less a neutral position. When it comes to a referendum, you have a different situation in that the people managing the referendum has one side in the election, like in this thing for the Racine Unified School District. Racine Unified School District wanted the referendum. They ran the referendum. So when there's a recount, they run the recount, and that's where the law fails, because it should be a neutral party, just as it would be when there's two candidates competing for a particular office.
Well, even with all that, you still have the right to look at the ballots.
Oh,
that
right,
you feel
right.
were
No, I understand.
miscounted.
Absolutely.
So-
And I think that was the genius of the attorneys in your case.
They stepped aside from this imbalance.
Right.
And
The
went over
shenanigans
to
that went on here was not
No, that's
brought
right.
to the court.
That's right.
What was brought to the court was you have an absolute right to look at those ballots.
Right.
And that's what came through this. Now the circuit court just never even addressed the issue. The appeals court said the judge has the discretion, and we're not even going to talk about it. Matter of fact, we're not even going to put any names on this. We're gonna rule on this. We're not even going to sign our name to it because it's so incredibly bad. Now it's at the Supreme Court, and now the Supreme Court, and let's face it, this is a miracle that it got there. And it was 8% of the cases in the state of Wisconsin that go to the appeals court get accepted.
Go to the Supreme
No,
Court.
no,
Supreme
they're
Court.
submitted to the Supreme Court. Yeah.
8%.
Only 8%. Yeah,
So
one
8 out of
six.
100, you're one of the 8. I mean, now here I got a question. Do you think that RSUD, Racine Unified, saw this coming? I mean, do you think it was over after the appeals court came in and said, we don't see nothing here? I mean, what's your gut feeling?
I don't. I think they figured this.
They figured it was a done
Yeah,
deal.
I think that they felt that we got a sufficient hearing at both the circuit court and appellate court. That's just the way they would think. Mm-hmm. You know, everything came out right. Our election was good. We deserve this. We have won by 5 votes, and they got heard at 2 levels. 2 levels. Now, why would the 3rd level come in and do anything different?
Yeah, because they realized you didn't actually get heard.
Well, I don't think they knew that, though. I don't think they knew that.
Well, no, it was
unless they
spelled
were
out in that
watching this
brief.
program, how would they know that?
Well, the Supreme Court
read the
knows
brief.
by the brief.
Well, the Supreme Court did,
Yeah.
but they weren't. They were expecting the Supreme Court to just not hear it, just to set it aside. And
Exactly.
they even said in the article that
probably
they were
figured-
very disappointed.
We got a
that this had
92%
occurred.
chance that the Supreme Court's just going to can this.
Yeah, we are. Let's see, Stacy Tapp. This is the RUSD's chief communication officer. She said, we are disappointed. See, they're disappointed that the Supreme Court is going to hear it. They didn't. It's not they're disappointed in the outcome, because there has been no outcome. They're disappointed that the Supreme Court even agreed to hear it. That's how they're thinking.
Well, I think everybody realizes that it hasn't really been looked at. I think, in my personal opinion, is that the appellate court would prefer that this election is fine, you know?
Right,
Oh,
of course they
absolutely.
would.
Put that $1 billion in the pockets of
Lisa
RUSD.
Baby and the rest of the little cootery there, they all think,
They figured we're just
going to be good enough.
We're just going to ignore this, and
Yeah.
if the Supreme Court wants to pick it up, and the chances are that they probably aren't going to, so this is a done deal. So
It'll all just go away.
yeah.
Don't have to worry about it.
Okay. Are we back to 50-50? Because I'll be honest with you. I read this. I read the brief. I read exactly what's going on. You're at a state statute. It actually, I think you got a pretty good chance of having this heard and being able to get in and look at those ballots. I mean, if they played it, the Supreme Court can do a million different things. You know that.
What's this 50-50 stuff?
Well,
are you
back
calling in an old bet, Jim? Did we take a vote somewhere online? And you
Well,
said
I
50-50?
figured after the
He's
appeal.
bragging again.
Here's the deal. I think that your petition, your case, I think has a pretty good shot at the Supreme Court.
I was surprised when I got a call from Samir, our lawyer, and said, "Guess what? The Supreme Court has accepted your case." I just, I thought, wow, because I did not expect it at all. And it wasn't until I parked the car, I got this while I was driving around town. I parked the car and sat there for a minute, and then I read his text, and I thought, holy mackerel, we're going to the Supreme Court. And I thought that's when, that's when I realized that, that something different had really happened. Now, it's kind of exciting from our viewpoint that it got taken, at least from mine, because I just given up on it. I'd given up on the court system. I just figured, it's going to go through. I'll survive it. We're all, it's not going to be the end of my world that the Racine Unified gets to waste $1 billion over the next 30 years. That's not that big a deal. But so it was exciting that we're going there. That doesn't mean we've gotten any place yet. We've just gotten a hearing, because there's a couple things have to happen now. One of them is what we're explaining now, is you've got this old statute that's been on the books for 116 years, and as far as I'm concerned, it's a good one, but times change, and this I think that
it's been challenged. 1933, they did challenge it. It was on something similar to it, and this is where the case for RSUD's attorneys were using, saying, "Well, Your Honor, they upheld the fact that the Board of Canvassers upheld that election in 1933, and that was two candidates were running for county clerk. One had lost by 7 votes, but the problem there was it was the way the ballots were stored. It wasn't a count. This specifically talks about a count.
This is about the arithmetic.
This is about the actual numbers. And those numbers, and I talked to Bobbitt, who was one of the attorneys, and he said, Jim, we spend hours and hours and hours, and I know darn well because I was there with you, and the hours that were spent breaking down all of that and looking at those numbers. Now, I mean, I got to give those attorneys credit because they put the time in and the effort in, and they did a great job, and I think they framed this perfectly to take this all the way to the Supreme Court, and I think he got a pretty good shot.
When he first explained what was going on, I didn't fully understand how explicit it was. I thought it was more along the lines of, we have a right to look at the ballots. We have a right to check them out, and if we get rejected, then no one's going to be able to look at them again. And I thought, it sounds a little far-fetched to me, but maybe yes, maybe no. But then when I saw the actual statute, and then it was just recently I saw that statute, and I thought, wow, this could be very important because it's right there in the law. And it's interesting about rights, if it's a right, it's a right. And nobody can come around and say, and supersede that and say, no, it's only a right if I say it's a right. No, if it's a right, it's a right. We're endowed by a creator with certain unalienable rights. Well, this is a legislature saying that it's a right. And they didn't say, providing a judge agrees with it. It was just.
Well, I hope that the court realizes.
Which is now what we're putting. We're going to put this caveat in there that it's a right as long as the judge agrees with it. Now, the way I understand that these courts work, and this may actually happen, they will go into the minutes and the records of the Assembly and the Senate and of the legislature, basically, and find out what was the discussion like and what were they saying in those discussions. That's actually been done. Whether they're going to be able to go back 116 years and do that, I don't know, because a lot of times in the courts and way to interpret this, they want to find out what was going on with the legislatures when they put these words down and what do those words really mean. So I'm just saying that I agree. Of course, I have a interest in agreeing with that we should have a look at those ballots, and I can see why I think we should look at those ballots and why I think that the legislation is correct in saying that we have the right to look at those ballots. How the judges will look at it and how Doc's going to explain another way to maybe look at it, it's still open game.
It's a very, very basic issue, and it's a question of when you have been when you've had a right described as belonging to you. Is that true or is it not true?
The wording of the law says that it's a right. There's no caveat in there that says, providing the judge says it's okay, that it's a right. Are they going to stick a caveat in there? Is the Supreme Court going to say, Yes, the legislator says it's a right, but the way we interpret this would mean it's a right, but providing there is a judge's agreement to
Well,
that.
you know, George, I don't see that happening.
I think they're kind of backed into a corner.
I think so too. I think this, like I say, I think they framed this, these attorneys framed this perfectly, because they're going to have to come in and say, okay, well, you got to have a judge do it. Well, what about a sewer referendum or another school referendum or you know, a village committee that is going to be voted on? All that would play into this then. So then it would be, well, if there's a recount or if there's an objection to the vote count, well, then it has to be the judge. So the judge becomes the arbitrator.
Well,
of your
yeah, because
vote?
that's the other side of it, right?
Yeah.
Is that then every time this comes up and somebody brings up this law, they say, okay, all right, we agree with that, and back to Sewell versus Racine Unified School District, but a judge has to come in and
make the final decision.
Make the final
I don't
decision.
think that's happening.
Well, this impacts the basic definition of what a right is. And if a right is dependent upon a judge approving that you have a right or consenting that you have a right, then do you really have a right?
Well, this is
That's-
a pure
and that's-
issue of
that's
the
gonna-
law.
it's gonna
That's
affect-
exactly what it comes down to, the
Yeah.
issue of the law. Perfect issue of the law. Is this a right or is this not
Yeah,
a right?
and one of the things they might look at is, can the legislature just declare something a right? Rights are considered something very sacred and basic. You know, we are endowed by our Creator with certain unalienable rights. When you come into a right with regards to human activities, I mean, there was a time when you had a right to own a slave in this country. See, so you get, when you get into a legislative right, you're getting into something that's a little
I don't think
trickier
they can go
than
there
a
on this.
basic right.
On you're talking voting, George. I think this is going to be one where the Supreme Court's not going to overstep their boundary into the votes or to people's right to vote.
Jim, I'm all for that.
I get you. I know
I'm
what
just
you're
saying what I have seen in the courts, because I've done in other areas. I've done a lot of research on certain laws and stuff, and it's amazing how these rights come out and
Yeah.
judges.
Okay,
and
well,
Supreme Court
we got to
and
go. I know we're running
Well,
out
I
of
got
time.
one more question
Go ahead.
first before we go, and that is why is Unified School District and all of the people that are in favor of this having passed, why are they so dead set against this going to the Supreme Court?
Why are they so dead
If-
against now looking at the ballots?
Well, that's what
bottom
I'm
line.
talking about.
Yeah.
You know, if there's nothing wrong with the process, the procedure, and the final count, then they should welcome this.
Exactly.
they should say,
you guys are worried about it? Look at the ballots.
Well, that was
It's
one
all-
of the
it's all-
arguments.
it's all- it's
Now,
all
that-
right there. Just look at
That
it.
was one of them,
Yeah.
and they said in 1933, when this other case was, they basically came out and said, well, the Board of Canvassers, they were sufficient for the review, but that didn't mean what they really extended it to was saying the ultimate decision maker was the ballot.
Well,
The ballot told the story.
this should never have gone to court. It never
Right.
should have gone that far. They should have gone up to you and said, "Well, listen, you got a problem with how many words?" It was like
It was like six or
or
no, I
seven?
think it might be nine.
which ones are they? I would go to you. I'd say, which ones are they?
This should have been
let's
handled in
just take a look
circuit
at 'em.
court by the law.
It should have been handled by the canvasser.
One of the ridiculous statements they said in trying to defeat what I wanted to do was saying, well, we're not going to redo the recount all over again. I'm saying, no, I'm not talking about all
And that's what this
60
law,
wards. I'm
this is
talking
exactly
about
what
9 of them.
that statute
And it's
states.
just a
a couple,
number.
and it's looking, and this is specifically what we're looking for. We're not going to review the ballots
How far
again,
is
and we're not
Unified
going to review
gonna
the
go?
envelopes. And
All right,
that
let's
kind of
just
stuff.
say, for instance, it's a beautiful day, and the Supreme Court comes back and says, George Myers and group, you get to look at those ballots, and we're going to send it down from the courts, and we're going to have you have that opportunity.
That'd be good.
How far is Racine Unified going to go from that point to keep you from looking at those ballots?
If they appeal it, that would indicate to me that there's something stinking going on.
Well, my guess is they'll appeal it.
From the Wisconsin Supreme Court?
I don't know who they can appeal it to.
No.
Well, you go to federal court, can't you?
No,
No,
that's
no, I
federal.
think
Federal law is where you go
Okay,
to.
all right.
Yeah,
okay.
no, they're kind of stuck with that. The only way it would happen if over here in some other state, Iowa or someplace, there's a similar case coming up the line, and it comes up with a different decision than our decision. Then the United States Supreme Court will listen to it, because then they feel like they have to decide which state is right.
You kids quit fighting.
Yeah. Which I think is phony. I think both states will have
Okay, George, let's
laws,
go one
but
step
that's not the
further.
way it
I know we
works.
got to go, but all right. Let's just say you get a chance to look at those ballots. When you really look at those, are you going to bring in a team, or is it George Myers?
Oh boy, you got to ask me a tech. I have no idea.
Okay.
You know, right now, I'm not. That's a second step down the road. The first step is I have the right now to look at them. Now we have to decide. I mean, who's going to touch the ballots, and who gets to look at, who gets to do this and who gets to do that. And one thing is, I will want to watch. I know what I want to do. Just exactly how it's going to get done.
Well, it's a great.
Don't have
It's a great.
Why is it that an educational institution doesn't understand civics? That's what I'm-
Yeah.
And
They don't
with,
teach it anymore.
and with that, we're going to take off. We appreciate you being here. We'll keep you posted on this. Come back and see us next week.